Well, it seems investigators in the Laci Petersen case had a mountain of potential evidence and didn't even know it. In court papers, authorities said they unknowingly recorded as many as 176 more phone calls by Scott Peterson. Police say they have yet to listen to those calls. They're asking the judge how they should proceed. So you may be asking yourself how someone could have recorded 176 phone calls and not know it. The answer is apparently technologically somewhat complex. And to put it into non-complex language, I'm joined now by Robert Mann, president of Worldwide Intelligence Network. Mr. Mann, thank you very much for coming on the program.
Pleasure, Dan.
All right, so explain to me, in layperson's terms, how it is the authorities could be wiretapping Scott Peterson's phone for weeks and now suddenly come forward and say, hey, you know what, guys? There are actually 176 more calls that we didn't even know we had.
The number sounds large, but in reality, according to the information that I've been able to gather, there were over 3,800 conversations that apparently were recorded. That's a tremendous amount of conversations within the period of 1 month. As far as the 176 that they didn't know about, it is understandable when there is a peculiarity involved in the equipment that is doing the recording. To understand how the equipment works, let me just start from the beginning. There is technology today, and there was a law passed and implemented as recently as June of 2000, where all devices such as pagers, cell phones, landlines would have to be developed by the manufacturers to have a dual purpose, one for the recipient to be able to hear and the other for law enforcement to be able to hear. So when this technology was incorporated, and the technology begins to work as in the Peterson situation, there is devices that are doing the recording off-site. And the off-site recording is being taken down by instruments. And I understand that AT&T had a glitch in their technology, which caused a lot of the recordings to be recorded without the knowledge of the people that were supervising the instrument taking in recordings.
All right, fair enough. Ted Simon, is that fodder for the defense?
Well, it probably will be, because in, a hard wire or this type of intercept is the most strictly enforced because it's the most invasive. And what happens, the court imposes an intercept order and the government has to abide by it. And it directs the authorities to listen, restrict the monitoring as to certain parties, restrict the monitoring as to certain types of conversations, and they have to minimize. So they're supposed to be listening so they can turn the machine off and not hear what they're not supposed to hear. Now, the flip side of that, someone's going to say, well, we didn't hear any of this. And that's just something that may have happened, but it's hard to believe. They probably should take all the information, turn it over to the defense, and let them listen to it first.
Gloria, what do you make of this?
Well, I think what occurred was exactly what should have occurred. As soon as it was brought to Mr. Jacobson's attention, according to reports in the news, Mr. Jacobson, the person who was to monitor the wiretaps, he immediately, after hearing just a few seconds of somebody with a southern drawl, realized that he hadn't heard these conversations before and turned it over to the court. What more should anybody do? It's not his fault that he hadn't heard it before. They were in the computer server.
That's fine. It may not be his fault. It may not be his fault, but when there's going to be an entire hearing on the question of whether this wiretapping was done properly, this doesn't seem to help the prosecution, that in essence they're going to be saying, you know what, we didn't quite understand how our technology worked.
No, Dan, here's what happened here. This is computerized, and the monitor who is listening to the tape then turns the recording on. Technology did not signal the monitor to turn the recording on. They find out there are, out of 4,000 calls, 176 that they were never signaled to listen to.
Right.
So they didn't listen. So what is the harm? No harm, no foul. The judge will now listen to those tapes and decide whether or not they are privileged, non-privileged, and by the way, there may even be a smoking gun in there for the prosecution. No one's been harmed here, and a judge will literally listen from start to finish.
I would agree with you, Janine, if it weren't going to be the case that the issue that this court is going to decide in the very near future is going to be, did they wiretap properly? Did they sufficiently ignore, for example, attorney-client conversations, etc.? And this does make you wonder, did they know what they were doing?
Well, there's no reason to wonder.
Why, Gloria? Why is there no reason to wonder?
There's no reason to wonder because it can be explained you know, as an issue of technology. You know, there's no malicious intent here.
But
and I don't know whether the defense is going to try to suggest it or not.
Go ahead, Ted.
Except that there's an intercept order that's put in place in all these cases, and the government has to abide by it. And one of those things is they're supposed to listen and then turn off when they're not supposed to listen. So that means they were just wholly abrogating their duty.
Ted, you're mixing up two separate issues. We're talking about things that they didn't even listen to because technology didn't signal them to listen to the conversation.
But, Jeanine, as you know, the intercept order directs the government how they're supposed to monitor conversations and how they're supposed to listen and turn them off.
How to do their job?
No, but the question is going to be what the judge told the government to do.
Let me ask Mr. Mann. Let me ask Mr. Mann a non-legal question. Is this trouble?
I don't think so. There's technology involved here, and whenever you use technology, be it given permission by the courts, it can go haywire. And of 176 conversations out of 3,800, it's not terribly unreasonable to think for just a moment that perhaps the person monitoring the machine where the recording is being done might have left a disc under a piece of paper by accident as he took the other disc to a prosecutor and then realized. But when he did realize
every time that happens in a criminal case, hang on a second. Every time that happens in a criminal case, and look, and very often it is accidental, and often it is very explainable. But, you know, remember, Mr. Fung in the O.J. Simpson case, it was the same sort of issue, which was that Dennis Fung, the criminalist, had accidentally left something in one place, and it becomes the biggest deal in the world.
But this is very different because apparently, according to news reports, this, the fact that these calls were in there and the server was brought to the attention of the person who was supposed to monitor the calls by the software expert. So there may not even have been any negligence here, let alone any malicious intent.
But you're missing the point. The point is the judge sets an order that tells the government how to operate these wiretaps.
But they don't tell them technologically
But they're
how to do it,
supposed to be listening and filling out logs and indicating what they've heard so they can minimize phone calls that they can complete. They can say whether or not they've completed their investigation.
What do you do?
10 seconds.
What do you do when Scott Peterson is talking to his attorney? You need to listen to that conversation for a few seconds to determine whether or not it should be turned off.
Mr. Mann, I got to wrap it up. Janine Pirro, Ted Simon, Gloria Allred, Robert Mann, thanks a lot. Appreciate it. Thanks for watching. I'll be back here tomorrow at 9 p.m.